Honorable members, the motion for consideration of the bill and the amendment moved thereto are now open for discussion. I now call upon the members whose names have been received for participation in the discussion. Honorable Sri Sujeet Kumar ji.
Thank you, Deputy Chairman, sir. Sir, I'm so glad I get to speak on this bill on behalf of my party, Biju Janata Dal, because I was part of the Joint Parliamentary Committee to which this bill was referred to, and B, because I firmly believe that this is one of the finest examples of sound public policy. I completely endorse Honorable Minister Piyush Goyalji's optimism that he shared and his objectives of this bill, which is so eloquently outlined with impressive facts and examples. Sir, he already has given some context. I would like to supplement and add a few more context which will tell why this is such a forward-looking bill. Sir, this bill has three key objectives. One is ease of doing business. Number two, ease of living for the common citizen of this country. And number three, to reduce the burden on our courts. Sir, every year World Bank brings out with a report called Ease of Doing Business report. Sir, in the year 2013, India was ranked a very lowly 132 out of 185 countries in the Ease of Doing Business report, which improved to 63 in the year 2020, for which the report is available. Very impressive jump, sir, from 132 in the year 2013 to 63 in the year 2020. And I sincerely compliment this government for bringing many path-breaking reforms which has helped us to make this quantum jump from 132 to 63. But, sir, one area where we seriously lag behind, and we could have been in the top 30, not 63, is the enforcement of contract. It is pretty much impossible today, sir, in our country to enforce a contract. I would not go into arbitration and other things because that's a different thing, but we have funny situation where two Indian entities are arbitrating in a third country because it's difficult to enforce contract in our country. But, sir, though the pictures are rosy, there are some elements which are still concerning for us, and I would like to mention a report by Observer Research Foundation, ORF, one of the leading think tanks of our country, titled Jailed for Doing Business. This was published in the year 2022. This highlights that there are 1,536 laws. Sir, you have heard it correctly, 1,536 laws in our country that governs businesses. And more than half of these laws have imprisonment clauses. So which means over 750 to 800 laws in our country which governs business have imprisonment clause, and which can land a businessman or an entrepreneur in jail. Sir, on an average, there are about 10 changes in our regulations or compliances on a daily basis. 10, sir, 10 changes. And as Honorable Minister was saying, ignorance of law is no excuse. Our entrepreneurs are expected to keep tab of all these changes on a daily basis instead of focusing on their business. Sir, you know that the consequences of criminal liability is immense. It has huge impact on a person's liberty. And sir, if a person is put in jail in our country, you know what a big social taboo it is. The person's social status is almost decimated if the person spends even a day in jail, even for a minor offense. So, sir, there is another element in criminal jurisprudence, in criminal law, called mens rea. Criminal intent or a guilty mind. That is paramount. That constitutes a crime. But, sir, in our country, entrepreneurs businessmen are often jailed for very petty offenses when they don't have any intention of committing the crime, for unintentional ignorance of law or for minor lapses, sir. Sir, this is because of the narrative that has been prevalent for decades that wealth creators are evil. Wealth creators are equated with hardened criminals in our country, sir, which is so unfortunate. They create wealth for the nation, they create jobs for the nation, and they are equated with hardened criminals. Sir, this affects the most our MSMEs and our startups. Sir, on an average, today an MSME or a startup in India has to spend about 10 lakh rupees a year just on compliances, 10 lakh rupees a year for a startup. And we all know that MSMEs are the mainstay of our economy. They create the jobs. They provide employment to our youth. And, you know, if this is the state of affairs for MSMEs, sir, then it's very concerning. Sir, we can come out with many schemes, many incentives for MSMEs. But unless we tackle this regulatory cholesterol, then I don't think, sir, we'll go too far. Sir, who are the greatest beneficiaries of all this? Honorable Minister mentioned lawyers. Lawyers, chartered accountants, company secretaries, they are the ones who are providing legal angioplasty. They are the ones who are providing regulatory strengths to cleanse this regulatory cholesterol. So this is the context, sir, in which I think this bill has been brought in and for which I really believe that this is one of the most forward-looking bills. Sir, I spoke about the ease of doing business. Let me quickly tell you that this bill also brings ease of living for our citizens. It's a loud statement that we trust our citizens. What Honorable Prime Minister had said, minimum government, maximum governance. This is the bill which talks of minimum government and maximum governance, sir. Sir, reducing burden of judiciary. Sir, we all know what the state of our courts are. We all know that there are over 4.5 crore cases pending in our courts, the lower courts, high courts, and the Supreme Court. Sir, today, sir, we have a situation where we are unable to compound our offences when the two parties are interested to settle the disputes, but the law doesn't allow them. So, sir, this bill envisages settlement of large number of issues through compounding, and also, sir, it converts many fines into penalties. Sir, fines are adjudicated by the courts. Penalties are imposed by an adjudicating authority from the executive. So, sir, this will declog our courts and help common citizens of this country and our courts to save time, resources, and energy. Sir, there are some critics, sir, who have raised concerns that reducing the or removing imprisonment as a punishment for the offences and converting fines to penalties might embolden the unscrupulous elements. Sir, I would like to allay these concerns by pointing out that the bill has significantly increased the penalties as compared to the low fines. Sir, there are fines 10 rupees in our statute books, 10 rupees, 100 rupees. Meaningless, sir. It's a joke basically. So this bill has significantly increased the penalty to manifold instead of having such low fines, which I think will be a deterrent. Also, sir, the bill proposes to increase the fines and penalties for some offences by 10% after the expiry of every 3 years from the date the proposed act commences. So I think, sir, these are the reasons why the critics' concerns are not justified, and also none of the grievous offences have been decriminalized. So grievous offences will continue to be in the statute books. All the offences in the IPC and other statute books will continue to be there. Sir, I would like to point out 2 or 3 things for the consideration of Honourable Minister. Sir, the bill omits all offences under the Indian Post Office Act of 1898. Sir, this includes the unlawful opening of the postal articles. Sir, if the postal staff or any other person opens any postal article, sir, that will be a serious invasion into the privacy of the person who has dispatched or the person who is supposed to receive the article. So I think, sir, this should not have been omitted, particularly given that it is not even there is no punishment for this even in the IPC. And also, sir, given that in 2017, Honorable Supreme Court has said that right to privacy is a fundamental right. So in that context, sir, I think the offence of unlawful opening of postal articles should not have been removed from the statute book. Sir, the bill creates an environmental protection fund for creating awareness, education, and research related to protection of the environment. Sir, I don't understand why that is there in this bill. A, because the state pollution control boards and the central pollution control board already has a provision of fund for environmental education, and I think this is an overlap, unnecessary overlap. So I think this could have been done away with. Sir, next, sir, the adjudicating officers who will be responsible for awarding penalties, sir, they may not have the necessary competence or the judicial bent of mind to decide on the penalties, because it requires a certain judicial discipline, it requires a certain judicial way of thinking. And also, sir, in many cases, the government itself is a party. We all know that in our country, government is the biggest litigant. So when you have government as one party and an officer of the executive, the adjudicating authority or officer, we don't expect her to rule against the government. So I think that impartiality also might be affected. But overall, sir, I think it's a very forward-looking bill. I will end, sir, with a few suggestions and would request Honorable Minister and the government to look into them. Sir, not only 189 provisions across 42 acts of 19 departments, we still have hundreds of other provisions in various other statute books, sir, which needs to be reviewed and need to be relooked at. So I think, sir, the government should come up with an SOP which will have a periodic review of all such laws. All the old and obsolete laws which Honorable Minister was talking about needs to be reviewed periodically. So an SOP is needed for this, and in future also I think the government should come up with similar legislation to do away with our old and obsolete laws. Sir, the reverse also is true. Today the social norms have changed. Today there is an influx of technology in our lives, which means that there are some offences which were petty in olden times, but today have become very serious and grievances. So this necessitates that certain offences might call for a higher punishment. So I think the reverse also is true. And sir, thirdly, I think the bill should have a retrospective effect so that the pending legal proceedings in respect of the offences being decriminalized might be abated. And finally, I think, sir, that the government should urge and issue an advisory to all the state governments to have a relook at their own state laws on similar lines so that the state laws also, which are old and obsolete, can be done away with from our statute books and also decriminalized in appropriate cases. Thank you, sir.
धन्यवाद माननीय सुजीत कुमार जी।